We've had clients come to us who have had complaints made against them in the workplace. Complaints, for example, of some sort of sexual harassment, some sort of inappropriate touching, and the question then becomes, what happens now, and do I need a lawyer when I'm answering my boss's questions or the human resource director's questions? My answer to that is you need a lawyer, but you may not be entitled to a lawyer. It depends on who the employer is. In some settings, for example, in municipal settings where there are union contracts or there are provisions of state law that cover the situation, the employee may be entitled to have an attorney present at what we call a disciplinary interview. In the private setting, the employee typically has no right to have an attorney present when being interviewed, and our experience is that a request for the presence of an attorney is usually met with an affirmative no. I will also add that failure to answer an employer's questions concerning a complaint may be deemed to be insubordination and could give rise to some disciplinary action, including termination. The only caveat that I'm going to add to that is that when the allegations or the complaint could involve some sort of criminal charge, for example, a sexual assault, there are Fifth Amendment implications. In other words, implications that you're admitting things that you really don't have to be admitting, and that is when the bell should go off that those questions, even if you're charged with insubordination, should not be answered.